I have my paper in the background here, and I really wanted to use it. And in fact, I recorded a great video with various items on my paper. Now I realize I can't use that video because when I turn, you can't hear me talk. So I'm going to try and replicate what I said and just not worry about my background here. Maybe someday I'll have some more technical abilities, but for now, I just want to get some thoughts out about what I did say. So I was talking about real estate in a probate estate versus real estate in a trust, because last video, I mentioned that I had just had a meeting with a nominated executor. So she's nominated in a will to act on behalf of the estate. But as we were talking, we were realizing the complications that we were starting to have as far as putting together a probate petition. And how if I were working with the person who was preparing her will, I would have at least wanted to have a conversation about how her major asset, her real estate, could be transferred to a lifetime trust, which would have various benefits, such as property management during her life. And then the real estate would avoid probate upon her passing, and how that could be very beneficial for those that she wanted to benefit. Because when I was meeting with the nominated executor, the idea was, why does a person have a will if they have to go through all of this other stuff? I can't believe it. And that brings out the biggest point, is that when you have assets, including real estate, going through this process called probate, and that's a word that is generally used to refer to the process required to get assets from an individual's name out to other people. You have to go through this probate process, and how that process, first of all, is public. Second of all, has various rules and requirements. And unless everything is done properly, we can't even open an estate. So you can have complications even in regard to opening an estate, and that depends on the various facts and circumstances at the time, which is quite interesting when you think about it, because when you are preparing your will, the facts and circumstances can be so different by the time you pass, including your next of kin and distributees. And as I mentioned in my last video, those are considered necessary parties to a petition to open an estate in surrogate's court. You have got to get a handle on all of the distributees. They have to be stated in the petition, whether it's a probate petition where you're looking to have a will admitted to probate, or an administration petition where there is no will and you're going by the laws of the state. So because of that, in getting all of those necessary parties named and their addresses, and have them agree to the appointment of a person / agree to the will being admitted to probate, and all of the problems that can ensue just in that way, when real estate is in trust, it bypasses all of that. The trust agreement is what matters. So when the property, the real estate, is transferred to the trust during life, the trust agreement has all of the rules as far as who should act on behalf of the trust and what should happen to the real estate. There is no time lag as far as what we would go through in surrogate's court. We just have a death certificate. We could put an affidavit on record as far as stating a few things, whatever it is at the time that's necessary, and then off we go and do whatever we need to do pursuant to the terms of the trust agreement. So versus a public record versus a time lag versus getting jurisdiction over necessary parties and all of the other problems that can ensue, we have this private matter, no time lag. We just follow the terms of the trust agreement. that successor trustee takes over and does what is needed at the time. Now, in both instances, we can think about taxes as far as what happens upon a person passing. That's often a question I get. And in both instances, we can have what's called a step up in basis. So we can have a step up in basis both with the trust, the assets in trust, as long as everything is handled properly in the planning end. And we also have a step up in basis through assets passing through the probate estate. So no difference there. As far as a tax ID number, if we have assets passing through a probate estate, we would obtain an estate tax identification number. As far as assets passing through a trust, if a trust tax ID number was not obtained during life, then we would get one upon the person passing. Now, during life, the Social Security number is often used, and that's something that you can work out with your estate planning attorney. Now, in both instances, you would be thinking about things such as who has the original search and survey. Here in New York, we still use those title documents, unlike just passing title insurance. You would think about utilities. Who's paying utilities? Who's on the account for the utilities? How can somebody manage and pay those both during life and upon passing? What about homeowners insurance? Homeowners insurance through a probate estate has problems. There can be a gap as far as obtaining or keeping that insurance in place, and that's a problem, versus a trust where we can have homeowners insurance continue on smoothly, no problems. We want to think about other things such as who's living in the home, who may be living in the home, what are the short-term needs and goals for the real estate, what are the long-term needs and goals for the real estate, and so on. But I want people to just think about real estate as a very unique asset where great planning can be done. The difference of night and day, really, when it comes to dealing with real estate. I can see a lot of problems unfolding when people don't really think it through versus realizing what can be done and how things can be so much better, again, for themselves during life and upon their passing for those they want to benefit. So hopefully one day I'll get some better technical abilities here and actually be able to use the paper in the background. I did write out some things, but I can't use it because I realize when I turn around, you can't hear me. But I hope this did help. I'm really just trying to let things go a bit as far as getting some thoughts out there that can be helpful for people. And I hope you'll subscribe to the channel if you haven't already. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I do look forward to seeing you on another video.